Bank Service Act forbids the acceptance of a deposit from an American citizen.
Welcome to Wells Fargo Home Mortgage Customer Care and Recovery Group. This call may be monitored and recorded. To assist in routing your call, please select from one of the following options. If you know your party's extension, please press 1. If you are, please enter the extension now or remain.
Thank you for calling Wells Fargo Executive Office. This is Jordan. This call may be monitored or recorded. Who am I speaking with?
Hello, Jordan. My name is I'm returning your phone call in response to some certified letters that I sent to Wells Fargo. You should know as well that this call is being recorded for documentation purposes.
Okay, I can consent to that. Thank you for returning my call. Give me just a moment to get back to the request here. Okay, so just wanted to attempt to let you know that we did receive the inquiry and I will be researching and responding to you. As far as the due date, I do have until the 17th to compile all the information and provide that to you, Mr. So I will be giving you another call and sending everything in writing for you as well.
Okay.
And just to confirm, we do have the address, let me just make sure.
The second address, that's the easiest way to get a hold of me in the proper way.
Okay, perfect. Perfect. All right, well, I will follow up with you once again once I have everything for you, okay?
Is that all, or I have a statement I'd like to make?
That's fine. Yes, go ahead.
It's rather lengthy. You'll have to bear with me, and I fully reserve all my rights regarding the scope of this interaction. Do you understand that?
Yes, sir.
Thank you. Before we proceed, let me clarify that your phone calls, nor this phone call, constitute an official response under the terms of my letter of intent, which requires a response within 20 days. You've already acknowledged that form of response will be coming to the team. So I just want to make it crystal clear that this call does not waive those deadlines or obligations, and if my written response is not received within the required time frame, it will be taken as evidence of concealment and bad faith. My statement that I have to make is somewhat lengthy, and some parts contain some questions which may require a yes or no answer. Please do not interrupt the statement other than to answer a direct question to you with yes or no. I'll let you know when I've completed my statement, and then if you wish to make a statement on your behalf or on Wells Fargo, you may do so. Following is not an exhaustive list of violations committed against me. I expressly reserve all rights to assert additional claims and causes of action in future litigation as necessary. Number 1, Wells Fargo's status as a foreign entity. You may or may not be aware that Wells Fargo operates as a foreign banking organization under 12 U.S.C. subsection 1841, and as such, it is restricted in the financial activities that it may conduct with United States citizens. Under 12 U.S.C. subsection 1843, a bank holding company like Wells Fargo is not authorized to transact with the general public, meaning that any transactions conducted with me need to be fully disclosed, as I'm not a financial institution. The promissory note I executed on 4/26/2011 in the amount of $265,000. Wells Fargo monetized that promissory note and securitized it, yet continued to collect payments from me for over 7 years, violating multiple federal laws. I have yet to receive my original promissory note back, which raises significant legal questions. The followings are just examples of some of those questions. Does Wells Fargo still possess my promissory note, or has it been sold, traded, or pledged? If it was sold, when, to whom, and for how much? Did Wells Fargo receive third-party payments on this note that were not credited to my account? Failure to disclose this information constitutes unjust enrichment and deceptive trade practices. Under 18 U.S.C. subsection 1005, Wells Fargo executives and employees can be held personally responsible for false banking entries and financial concealment. Under 12 U.S.C. subsection 503, Wells Fargo and its directors may be liable for personal profiting from the unauthorized securitization of my note. My forensic accounting records show that my ledger is complete, and I have a forensic accountant at my disposal who will attest to Wells Fargo's securitization processes, which means that Wells Fargo no longer has the lawful right to enforce or claim ownership of it unless full disclosure is provided. Upon belief in information pertaining to federal law, a cash collateral account exists or did exist in connection to my note, which means that a legal set-off should have been applied to the discharge for the obligation. If Wells Fargo failed to apply such an offset, that's further evidence of fraudulent concealment. Under 12 U.S.C. subsection 84, Wells Fargo may have violated lending limits, and under 12 U.S.C. subsection 375A, any undisclosed third-party payoffs or insurance proceeds are further grounds for legal action. I was entitled to receive the interest on the coupon payments I remitted each month. These payments constitute negotiable instruments, and I am legally able to collect interest pursuant to the indenture agreement Wells Fargo has on file with the SEC. Furthermore, under actions for injuries to personal or real property, actions for the detention or conversion of personal property, and civil actions based on any alleged violation of any federal or state statute creating a monetary liability for personal services rendered or liquidated damage or other recovery, therefore, when no other time of limitation is fixed by the statute creating such a liability. Since I only recently discovered Wells Fargo's fraudulent concealment of the securitization of my promissory note, the failure to disclose third-party payments, and unjust enrichment through continued collections after settlement, the statute of limitations has only just begun to run. Additionally, I retain a private right of action under 12 U.S.C. subsection 1978, which allows private parties to challenge the legality of financial transactions and banking practices. 18 U.S.C. subsection 1005 holds bank officers accountable for false bank entries and fraudulent transactions. 18 U.S.C. subsection 1640 TILA provides a private right of action against creditors who fail to disclose material financial transactions. I expressly reserve my right to take private legal action against Wells Fargo and any responsible parties for fraud, unjust enrichment, deceptive trade practices, and failure to disclose material financial information. This includes the right to seek disgorgement of profits, statutory damages, treble damages, and injunctive relief in a court of law. Therefore, should this instant matter be brought before a federal court, I will seek the following relief: disgorgement of unlawfully obtained funds and treble damages for unjust enrichment under applicable federal statutes. Declaratory relief confirming that Wells Fargo has engaged in deceptive trade practices, fraudulent concealment, and unjust enrichment in violations of federal banking laws. Injunctive relief to prevent Wells Fargo from continuing to engage in fraudulent financial transactions, securitization concealment, and deceptive lending practices. Punitive damages to deter future misconduct and penalize Wells Fargo for its reckless disregard for financial integrity and consumer rights. Statutory damages under 12 U.S.C. subsection 503, 18 U.S.C. subsection 1005, and 15 U.S.C. subsection 1640 for banks' violations of federal banking, fraud, and consumer protection laws. Attorney's fees and litigation costs is allowed under federal law to compensate for the burden of pursuing legal action against a financial institution engaged in willful misconduct. Personal damages against individual officers, directors, and employees of Wells Fargo who were or are directly involved in the fraudulent financial transactions, concealment of material facts, and unjust enrichment at my expense. These individuals may be held personally liable under 12 U.S.C. subsection 503, liability of bank officers and directors, 18 U.S.C. subsection 1005, false bank entries, 18 U.S.C. subsection number 22, 12 CFR subsection 211.10, permissive activities abroad. Activities usual in connection with banking. The board has determined that the following activities are usual in connection with the transaction of banking or other financial operations abroad, outside the United States. Commercial and other banking. Financing, including commercial financing, consumer financing, mortgage banking, and factoring. 12 U.S.C. subsections 1861 through 1865, the Bank Service Act, forbids the acceptance of a deposit from an American citizen, and jurisdictional operations are restricted to 12 U.S.C. subsection 1843, outside the United States. Number 24, the published regulations series 12 CFR subsection 211, foreign banking, lists the only permissible lien on real estate restricted to the extension of credit for foreign real estate. Number 25, 12 U.S.C. subsection 378 forbids national banking associations to be associated with any investment companies in regards to any asset located in the United States, and neither are permitted to accept a deposit from an American citizen. Number 26, 12 U.S.C. subsection 29 does not permit national banking associations to own real property other than a bank building or property mortgaged by an affiliate as a payment in regards to a debt owed to a member bank. Number 27, 12 U.S.C. subsection 615 restricts the business of banking, inclusive of deposit taking, to outside the United States. Number 28, 12 CFR subsection 250.143, section D restricts national banks to foreign branches outside the United States. Number 29, 12 U.S.C. subsection 631 refers to national banks as corporations. False representations as to the liability of United States for acts of the corporation can impose a $10,000 fine and imprisonment for not more than 5 years for even inferring that Wells Fargo has any connection to the United States. Number 30, National Bank versus Matthews, U.S., January 1, 1878, 98 U.S. 621, Mr. Justice Miller dissenting. Quote, I am of the opinion that the National Banking Act makes void every mortgage or other conveyance of land as a security for real money loaned by the bank at the time of the transaction to whomsoever the conveyance may be made, and that the bank is forbidden to accept such a security, and it is void in its hands, end quote. 31. I am not a covered person under the Private Securities Litigation Act, by definition a member bank subject to the interbank liabilities listed in 12 CFR subsection 206. Number 32, to provide for the establishment of federal savings and loan associations, the HOLA Act, by its subsection 3, 48 Statute 129, repealed subsection 4D of the Federal Home Loan Bank Act, 47 Statute 727, which have authorized federal home loan banks to make loans directly to homeowners. Number 33, CFR 12 CFR subsection 204.8, international banking facilities. Time deposit, or IBF time deposit, represents funds deposited to the credit of a non-United States resident or a foreign branch office, subsidiary, affiliate, or other foreign establishment that deposits received by the international banking facilities may be used only to support the depositor's operations outside the United States as specified in subsection 204.8A2II, and that extensions of credit by the IBFs may be used only to finance operations outside the United States as specified in subsection 204.8A3VI. Number 34, 12 U.S.C. subsection 375A, loans to executive officers of banks, an extension of credit which the bank is authorized to make under this section. Mortgage loans. A member bank may make a loan to any executive officer of the bank if at that time the loan is made, it is secured by a first lien on a dwelling which is expected after the making.
Hello, this is Jordan calling from Wells Fargo Executive Office regarding